You
Yes.
decide the
Yes, madam. Just give me a minute.
Well, I'll take a plea on the maintenance.
Yes, you can take whatever.
That's just two points.
And you can argue whatever you want.
If you're taking up your maintainability, then I think you'll have to argue first.
Yes, yes, yes.
You can argue. I'll find my written submission.
Yes.
Oh, it's fine. Sorry.
I'll take up item 1 first.
Yeah,
There it will not take more than 30 seconds. That was this is a selection to the post of lecturer in statistics in Cotton University. In the meantime, my lord, the petitioner has got a job in Ajjavidavit College. So she is no longer interested in pursuing the matter. So I'm making it easy for your lord, so that you can your lordship can devote the whole day for item 2.
Number 1.
Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr. S. Vishwakarma, Learned Counsel for the petitioner, submits that the petitioner has been appointed elsewhere
As lecturer in Ajjavidavit College.
Assistant
professor.
as an assistant professor in Ajjavidavit College, and therefore he has instructions not to press this matter. Mr. M. K. Chaudhary, Learned Senior Counsel, assisted by Mr. D. Mahanta, Counsel for Respondent number 6 is present. Just add one more name.
My lord,
Mr.
for
A. Shamwa.
my lord, if I invest the grants commission, my friend Miss Pooja Agarwal will hand
Ms.
it.
P. Agarwal for UGC,
Respond number 7.
respond number 7. Cotton University, Mr. P.D. Nair,
My lord, 10
Ah.
and
Mr. P.D. Nair, Standing Counsel for Cotton University, respondent numbers
10 and
10 and 11. And Mr. Sharma,
Higher division.
okay, Ms.
PR Mahanta.
A.R. Mahanta, Learned
PR.
PR, Mahanta, Learned Standing Counsel for Higher Education Department. Mr. Sharma is also there.
No, I'm just would like to introduce
Okay,
my friend.
Lord,
Okay.
actually, he's the standing counsel for UGC, but in this matter, he has some conflict of interest. So I am the panel.
It's okay.
advocate for UGC.
Isn't this was not first.
Obliged.
number 2.
Page, please, your lordship.
In this case, your respondent number,
My lord, we have been included as intervener in this case, my lord.
okay. Yes,
My lord, I'm raising two preliminary points, my lord. First, my lord, there is gross suppression of material facts.
yes,
Secondly, my lord, the impugn order which has been assailed in this case, my lord, that merged with another order which has not been put to challenge. So these are the two preliminary points which I would like to argue, my lord. If your lordship would kindly come to page 259, my lord.
Of the
Writ
writ
petition.
petition.
Yes. This is the order, my lord, by which on 9/11/21, the writ petitioner entity was, my lord, debarred by Oil India Limited for a period of 3 years. If a lordship would kindly come to my lord,
Just one, page number.
it starts at page 259 of the writ petition.
It will do. Yes, 259, yes.
259, my lord, 9th of November 2021 is the order passed by the competent authority. If a lordship would be come to the operative portion at page 265. First subpara. Further, I am also of the opinion that since the above breach was committed by Messrs. Drillmake SPA during subsistence of the Integrity Pact, therefore offense misconduct was complete on the part of Messrs. Drillmake SPA with the payment of commission, or even when invoice of payment of commission was raised upon Messrs. Drillmake SPA by Messrs. Continent Projects Technologies Private Limited. Accordingly, as per the proposition of law discussed herein above, appropriate legal proceedings as stipulated in section 3(1) of the Integrity Pact can be initiated against Drillmake SPA even after expiry of the Integrity Pact. And now therefore the undersigned in terms of section 3(1) of the Integrity Pact hereby holds Messrs. Drillmake guilty of breach of section 2(4) of the Integrity Pact, and as such debarring them from entering into any contract with Oil India and also carrying out any business with Oil India Limited for a period of 3 years effective from the date of issue of this order with effect from 9/11/21. However, procurement of proprietary items, proprietary spares, etc., will remain outside the purview of this order, and procurement of such item will be carried out when requirement arises. My lord, I don't intend to make any argument on the merits, my lord. I'm raising just 2 preliminary points. I think on merits, my Mr. Friend will argue, my lord. Now, my lord, what was challenged in this writ petition was an order of debarment dated 9/11/21. Now, my lord will kindly take note of one date, my lord. Writ petition, the date is not right.
That is that appellate order.
Yes, no, my lord. This is not the appellate order, that's the original order.
No, this is original. You are
Ah.
referring to appellate order.
Yes, my lord.
I read
Now, my lord will kindly come to page number, my lord. 266. This is the appeal they filed, my lord. Please come to my lord, page 274. The prayer portion. Therefore, it is humbly prayed before your honor, before your honorable authority, to allow this appeal by discharging Drillmake SPA from the impugned debarring order passed in terms of section 3(1) of the Integrity Pact for breach of section 2(4) of the Integrity Pact, debarring Drillmake SPA from entering into any contract and carrying out any business with oil for a period of 3 years, effective from 9/11/21, in circumstances of the matter and in the interest of justice. Further, it is humbly prayed before your honorable authority to set aside and grant interim stay of operation of the impugned debarring order pending hearing and disposal of the appeal proceeding, and pass such order or orders as may be deemed fit and proper as the circumstances warrant in the interest of justice, whereas the restraint inflicting of further civil consequential damage irreparable loss to SP. So along with the prayer for setting aside the order of debarment, there was a prayer also made for my lord, interim relief in respect of the debarment order. Now, my lord will kindly come to page number Roman 11 of the writ petition. This is where, my lord, my submission rests. At page Roman 11, my lord, in the list of dates, the date 16/11/21. Here, no? Page Roman 11.
Yes, yes.
Date 16/11/20. The petitioner filed an appeal against the debarment order dated 9/11/21 with the chairman and managing director CMD, All India Limited. It is pertinent to note that the appellate authority has not processed the petitioner's appeal and in any event has no power to place the debarment order in abeyance. Kindly see, my lord, this was filed on 13/6/22. Whereas the appeal was disposed of on 21st of February. And the statement is it is pertinent to note that the appellate authority has not processed the petitioner's appeal and in any event has no power to place the debarment order in it. It is something more than suppression, it is making false statement on oath. Before that, I'll place the page 14.
Yes.
My lord will kindly come to page 14. Now the averment in the body of the appeal. P. That agreed by the impugned debarment order, petitioner had preferred an appeal to the competent authority under Oil India's banning policy. So, my lord, the fact that the appeal was disposed of on 21/2/22 has been grossly suppressed because the writ petition was filed on 13/6/22. And the appellate order is, my lord, of 21/2/22. My lord, there is a distinct reason why they have chosen to, my lord, resort to this falsehood or suppression.
Please give me the date of that order, for appellate order.
21/2/22, my lord. My lord, that order even Oil India has not brought on record in any proceedings. We all know, they have not
No,
denied that date.
But in the notes of your argument,
Yes,
in the earlier matter,
yes, madam.
I find a reference to the letter number,
Huh.
DCOP, so
Yes,
and
because
so.
they have indicated in their affidavit.
Okay, that number I couldn't track.
Yes, yes,
Please show me that.
yes. I'll come, my lord.
Huh.
And before that, I'll just refer to one more order, my lord. Page 7.
Because this,
Yes,
in that, in your submission, I have recorded the letter number.
yes, yes.
I couldn't track it, therefore.
I'll come to that, my lord. 7. There are 5.
Perhaps it has happened
Yes.
because
Yes.
I did not make a note that the order is not on record.
My lord will kindly come to page 731 of the paper book.
Okay, that your volume.
Yes. This matter only, my lord.
7.
731. My lord, it starts at page number 729, the order passed in the writ petition, my lord.
I was apprehensive whether I would be able to go through this and all because of the commitments in the diamond, this
Platinum
Platinum
Jubilee.
Jubilee celebration, where I was to oversee that
That, I mean, that.
souvenir.
Souvenir.
So
Well, when we'll get the copy, maybe.
it'll be distributed.
Okay.
From today, it is,
Okay.
it has started. Because that SME's version of history and heritage, two things came up together.
Right,
So
right.
it took a lot of
No, lot
effort
of
to do that.
homework, yes.
My lord, is it possible for non-members also to obtain a copy of that?
That I'll not be able to comment because
I see.
ultimately it will be the honorable chief justice's prerogative.
Oh, I see.
The fact is that we have not been able to arrive at a consensus to give a price tag to that
I see.
Okay.
because it's a souvenir, price tag was not given. We had suggested that there be a cost to cost price tag, but what is principally agreed upon is that we'll have a soft version ready within few days.
Okay.
So these soft versions will be uploaded and anybody can download it. So that the soft version have been, we are planning to upload it in PDF form and then we'll upload it. So it can be available for all.
But see, even, my lords, even a souvenir, I mean, a physical copy is always, a souvenir always has more.
No, you are right.
And even if there's a price tag for non-members, it is worth buying. I mean, it
No,
would
it
be
is worth,
something
but
which other high courts
Principally,
they would be
we
interested.
will not be able to arrive at a
arrive
consensus.
at a consensus. Right?
Yes, I was trying to draw your lordship's attention to page 731, my lord.
731, yes.
Para 5. Mr. Sharma, sorry.
Yeah.
Yes,
Para 5, my lord.
yes,
Third line from top.
yes.
Mr. Sharma, learned senior counsel for the respondent has submitted that petitioner had preferred an appeal against the order, impugned order dated 9/11/21 in the meantime. And an order has been passed by the appellate authority in the said appeal on 21/2/22. By the appellate order, appellate authority has reduced the duration of debarment of the petitioner from 3 years to 1 year from the date of the impugned order, keeping in view so and so of so and so. In view of the matter, in such view of the matter, petitioner may not have grievance with regard to the order of debarment. It is submitted by him and it is open for anyway, my lord. I have referred to this passage only for the purpose of, showing my lord that even the All India's lawyer, while considering the impugned matter, my lord, this statement was made. Therefore, what follows therefrom is, my lord, the petitioner, while referring to the petition, choose to suppress the fact that against the order of debarment dated 9/11/21, an appeal was preferred and the appeal was partly allowed by order dated 21/2/22. So this aspect has been grossly suppressed. Now the purpose of suppression is what, my lord? Now this benefit of this debarment was given to them under the my lord 2021 guideline. Now they otherwise cannot admit because they are trying to say the arguments which they have made, my lord. From that it is very clear that somehow they wanted to, my lord, hide this aspect of the matter. Now, my lord, here therefore my submission is the petitioner is guilty of suppression of, my lord, material facts. This is well known, my lord. Candid disclosure of fact is a sine qua non for approaching a equitable jurisdiction, my lord. And there I will rely upon the judgment of the Supreme Court in K.D. Sharma's case, my lord, where the Honorable Supreme Court said, my lord, if a liberal view is taken in such matters, then it is not good for the administration of justice. My lord, K.D. Sharma is 2008, 12 SCC 481.
2008, 4 SCC,
2008, 12 SCC.
12 SCC, okay.
481. Now, my lord will kindly come to para 34 at page 492. The jurisdiction of the Supreme Court,
Paragraph,
para 34, my lord. The jurisdiction of the Supreme Court under Article 32 and of the High Court under Article 226 of the Constitution is extraordinary, equitable and discretionary. Prerogative reads mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all the factors before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. Then, my lord, para 36. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly herein bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes false statement, suppresses material fact, attempts to mislead the court may dismiss the action on that ground alone and may refuse to enter into the merits of the case by stating, "We will not listen to your application because of what you have done." The rule has been evolved in the larger public interest to deter unscrupulous litigant from abusing the process of the court by deceiving it. Then my lord will kindly come to para 38. The above principle have been accepted in our legal system also. As per the settled law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or of the High Court under Article 226 is supposed to be truthful, frank, and open. He must disclose all the material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek, to pick and choose the facts, like to disclose and to suppress other facts. The very basis of jurisdiction rests in disclosure of the true and complete facts. If material facts are suppressed or distorted, the very functioning of the writ court and exercise would become impossible. The petitioner must disclose all facts having a bearing on the relief sought without any qualification. This is because court knows law but not the facts. If the primary facts as highlighted in Kingston Income Tax Commissioner is kept in mind, the applicant who does not come with candid facts and clean breast cannot hold a writ of the court in a soiled hands. Suppression and concealment of material facts is not advocacy. It is a jugglery, manipulation, maneuvering, and misrepresentation, which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts fairly and fully, but states them in a distorted manner and misleads the court has inherent power to, in order to protect itself and to prevent an abuse of the process, to discharge the rule IC and refuse to proceed further with examination of the case of the marriage. If the court does not reject the petition on that ground, the court would be failing in its duty. I am on this line, my lord. So therefore, my lord, the law is well settled. Then another passage, my lord, at para 51. At page 497. Yet in another case in Vijay Sayal versus State of Punjab, this court stated, in order to sustain and maintain the sanctity and solemnity of the proceedings in law courts, it is necessary that parties should not make false or knowingly inaccurate statement, misrepresentation, and should not conceal material fact. With a
that
design
is which paragraph? 49
51, my
or
lord.
51, I'm sorry. Yes. Which is
Yet in
yes.
another case in so and so,
Yes,
this
yes.
court stated, in order to sustain and maintain the sanctity and solemnity of the proceedings in law courts, it is necessary that parties should not make false or knowingly inaccurate statement or misrepresentation and also not conceal material facts with a design to gain some advantage or benefit at the hands of the court. When court is considered as a place where truth and justice are the solemn pursuit. If any party attempts to pollute such a place by adopting recourse to make misrepresentation and in concealing material fact, it does so at its risk and cost. Such a party must be ready to take the consequence that follow on account of its own making. At times, lenient or liberal, generous treatment by courts in dealing with such matters is either taken or lightly taken instead of learning a proper lesson. Hence, there is a compelling need to take serious view in such matters to ensure expected parity and grace in the administration of justice. In fact, my lord, the Honorable Supreme Court has taken a very serious view of, my lord, suppression of material fact. The end of the bottom line is, my lord, if somebody comes with a solid hands, then, my lord, he should be declined the hearing on merit. That is the underlying principle which is, my lord, discernible from this case. Now, the other point which I would like to argue is, my lord, now, admittedly, my lord, 9/11/21 order has merged with 21/2/22 order. Now, that order is not under challenge. Now, the Supreme Court in one of the case, my lord, has made no exception between a judicial, quasi-judicial or an administrative order when it comes to doctrine of merger. So, in other words, my lord, 9/11/21 order has merged with the appellate order of 21/2/22. When that order is not under challenge, and this repetition is clearly not maintainable, my lord. In fact, that they should have brought on record the other order also, because essentially, my lord, on the day when the repetition was moved on 13/6/22, that order of 9/11/21 already merged with the 21/2/22 order. The writ petition was filed on 13/6/22, whereas the appellate order is dated 21/2/22. Now, that paragraph 12, my lord. Just one here. My lord, will kindly come to paragraph 12, my lord.
Yes,
Para 12. The logic underlying the doctrine of merger is that there cannot be more than one decree or operative order governing the same subject matter at a given point of time. When a decree or order passed by the inferior court, tribunal, or authority, my lord, will be covered by authority, was subjected to remedy available under the law before a superior forum, then though the decree or order under challenge continues to be effective and binding, nevertheless its finality is put in jeopardy. Once superior court has disposed of the list before it either way, whether the decree or order appeal is set aside or modified or simply confirmed, it is the decree or order of the superior court, tribunal, or authority which is the final binding and operative decree or order, wherein merges the decree or order passed by the court, tribunal, or authority below. So this is the proposition. So doctrine of merger cannot be confined to, my lord, judicial or quasi-judicial orders. It will also be applicable to any order, my lord, which is subject to any appeal by any superior forum. So because the use of the expression authority makes the position explicit, my lord. That idea is, my lord, the doctrine of merger will not only be applicable in case of judicial and quasi-judicial orders, but it will also be applicable to orders passed by the authority and a different jurisdiction. My lord. Then my lord will kindly come to paragraph 42 of the same order, my lord. 42 and 44. To merge means to sink or disappear in something else, to become absorbed or extinguished, or to be combined or be swallowed up. Merger in law is defined as absorption of a thing of a lesser importance by a greater, whereby the lesser ceases to be exist, but greater is not increased. An absorption or swelling up so as to involve loss of identity and individuality. Please come to para 44, my lord. To sum up, our conclusions are, where an appeal or revision is provided against an order passed by a court, tribunal, or any other authority, I'm on this, my lord. I'm laying my emphasis on this. Before superior forum, and such superior forum modifies, reverses, or affirms the decision put in issue before it, the decision by the subordinate forum merges in the decision by the superior forum, and it is the latter which subsists, remains operative, and is capable of enforcement in the eye of law. So I don't think there could be a more explicit, pronouncement than this para, my lord. Then my lord will kindly. So my lord, therefore, my lord, this summing up at para 44I is very clear that the order which the superior authority passes, my lord, it subsumes the order of the order which is appealed against. So it loses its identity, it merges with the subsequent order. Now, what has been challenged before your lordship is 9/11/21 order, which does not exist on 13/6/22. On 13/6/22, when an approach was made to this honorable court, 9/11/21 order did not exist in the eye of law. It merged with the order of 21 to 22, and that order was never challenged. And they were oblivious of the fact. They knew it, my lord. They have come up with half-baked facts. They've said that we have preferred an appeal, but no steps have been taken to dispose of the appeal. It's a very serious statement, my lord, which has a vital bearing in the adjudication of the issues. Therefore, these are my two preliminary points, my lord. Number one, there is a gross suppression of material fact. And secondly, my lord, by application of the doctrine of merger, the repetition is not maintainable. As admittedly, my lord, the order dated 9/11/22, which is under challenge, was no longer in existence on 13/6/22 when repetition was filed. And on merits, my lord, my friend Mr. Sen is there to take care of it, my lord. So I will not repeat the arguments, my lord. That's my humble submission. So, Lordship's kind permission, can I take it? Deeply.
My lord, my submissions are going to be very limited. As far as the conduct is concerned, my lords, of the petitioner, my lords, we won't comment on that. But from our part, my lords, I'm instructed that OIL on the day when we had the copy of that order, that was handed over to the court. My lords, the copy was not given to the other side, but that was handed over to the court. And my lord, the limited submission there, which I would make, is that if later on they could have always applied under RTI, etc., if that was such an issue, the appellate authority's order, then they ought to have applied under RTI, etc., and come and procured the order. My lord, they have not done that. They are arguing. I'm not taking sides as far as conduct is concerned. All I'm saying is I'm putting the facts before that we had put across. The order had been given to the court. It would be in the file of the court.
It's available. It's available.
Yes. So, my lords, the other side had not been given. So, from our side, my lords, from OIL, there was no suppression. What we want to clarify.
My lord, if I just may interject on.
Let him complete. You want to catch a bus? You want to catch a city bus?
No, my lord, I apologize.
Time-bound bus. Okay.
Apologies.
No.
And my lords, that stay order which was passed after that order of the appellate authority was before my lords. And it was therefore in the knowledge of my lords when that stay was passed. That is as far as the suppression is concerned. I will not go beyond that whether it's relevant, irrelevant, because that's for the petitioner to make out. My lords, as far as I am concerned, my lords, I will go straight to the integrity pact which was involved, under which the banning was done. And what was the reason why we did the banning, my lords? That's there in relevant parts of my affidavit, which I will just point out to my lords. This is the two limited points that we will say on the debarment.
No,
Madam,
in fact, there's no dispute with regard to the integrity pact.
Yes. Yes, absolutely.
You have done it, and what do you call, because we are now concentrating on the preliminary issue
Yes.
of maintainability,
Yes,
not on the merit. Merit,
Right.
I am not entering right now,
right.
because a preliminary point being taken, I have to adjudicate that first.
My lords, as far as maintainability is concerned, my lords, I am in a very peculiar situation because in a way, I'm against the writ petitioner. But as far as conduct is concerned and as an officer of the court, my lords, all I will point out are two things. One, we did not suppress the stay order which was passed taking into account the appellate order of the authority. It was very well open to them also to procure the thing if they wanted. In any case, my lords, the issue of maintainability should not hinge on, according to us, my lords, on this aspect, because the order was already there before. So whether it was suppressed, not suppressed, really becomes an academic question because the order was there before, my lords. That's my submission, but beyond that, I will not put any. Sorry, madam. May I just take a minute? No, that's what merits. You're looking at the maintainability. Yes. Well, that's on merits, whether that the banning, whether 3 years, 1 year, whether that is an issue on merits. But as far as maintainability is concerned, ma'am, that's a limited submission.
That part of your submission is already, we have
Yes,
already taken note of that.
Yes,
In the
yes.
earlier, you are saying that the planning was in the range of 6 months to.
that's 3 years.
Did you say that you have done it not under the new department policy, but you have done it because it was having a range?
That's it. That's it.
That's
Well,
a-
I'm grateful.
but-
Well, that's the only thing. As far as maintainability is concerned, my lord, as I said, I can't conduct on the conduct of the petitioner, but we were open before this court. The court had all the material before it to take a call. Yes, we did not give a copy to the other side as by instructions. Petitioner, sorry, we had not. So that's all right. That's what that is. Yeah. Yes. Yes, my lords. On merits, my lords, if my lords may want to, whenever, for us to advance the argument that whether 3 years or 1 year, whether it was proper or not, my lord, that we can. That has been partly argued in the other petition also. But my lords, we can supplement here also. With my lords.
It was only a preliminary issue.
Yes,
Then
preliminary issue.
then you go into, when if I sustain the writ petition, then you argue on merit.
On
If
merits,
if it goes on threshold,
yes,
then on preliminary issue, then everything goes.
my lords.
Yeah.
I'm sorry, my lords, I'm just trying to understand this instruction. So we, my lords, only the banning. That's the petition. Yes, petition. My lords, my only apprehension which my learned friend was expressing, which I'm
Yeah,
trying to-
just one minute.
Sorry.
Yes.
My lords, the only apprehension was that on merits, if my lords, no observations about, say, why it was not challenged, etc. That part we are only looking at maintainability, qua suppression. I mean, that's my,
Let me ask you a question.
yes,
It will clarify me because every day I'm, faced with this situation. Supposing I am taking up a matter for injunction.
Madam.
And I make a comment. When I deal with the prima facie case, I make a comment. According to you, it'll harm you on merit when the suit is taken up.
my lords,
So this same issue, you see, doctrine of maintainability is that if
I
I
understand.
touch upon a matter
Absolutely, absolutely.
and I decide a preliminary issue, which
Yes.
is within the meaning of, you see, I understand order 14 easily. Then what
But
you
those
call-
principles apply here also. Not
So
that-
once I make a comment there,
Yes.
it won't become a res judicata unless it is a finding of fact on
Not
that
at all.
issue.
Absolutely, absolutely. Absolutely, Malak. Only apprehension is, I think what happens is, it just increases the work. And Malak, that's the only reason that, even though it's a prima facie order, it can be used in various ways. So that's the only reason why one was making that submission, but I leave it at that, Malak. I will not press this point.
Last year, appellate order, if you see, copy two was not marked. I'm sorry.
That I said. Copy was not given to her. It was not given. That you said.
Because for me, if I can bracket anything within the scope of three things, procedure part,
Yes.
either criminal procedure or civil procedure or evidence, I've become more comfortable.
Malas, but that is always helpful in writs and other even commercial issues. Malas, today, for example, in arbitrations, international arbitration, Malas, there's a dearth of trial court lawyers who know how to do cross-examination, how to deal with the principles of procedure. Malas, there's a big dearth. A lot of people in appellate side, especially in Delhi, Malas, a lot of people miss out on this experience. So it's a very invaluable experience, and not many people are able to now tackle it. And that has huge implications for commercial disputes.
Yes, so you'll make your written submissions tomorrow.
Yes.
Okay.
Well, my learned friend made a statement that we would have made an application under RTI. We have done it, madam. And they have replied also. And they claim, my lord, the benefit of section 81D. And my lord, mere making a statement will not do. Kindly test the contrary statement made in the writ petition. The
that is
statement
true.
in the writ petition is, we have preferred an appeal, it has not been disposed of. So, my lord, there has to be a clear, unequivocal statement, my lord. Merely somebody placing in, of course, Mr. Yashan Sharma's argument was noted, my lord, by this honorable court. But even after that, the petitioner never came forward to say that yes, or to amend the writ petition. Now it is too late in the day, my lord. They are saying this information cannot be disclosed because it is exempted under section 81D.
Okay.
Manoj, I get this. But Manoj, even then in court proceedings, it could have been sought for. Manoj. That's not something which is.
No,
I
why-
leave it at that.
Why will the contesting respondent
Yes.
improve the case for the petitioner?
Manoj.
You have to respect Mr. Chaudhary for that. Just a moment. I
But-
release my secretary. Let her talk.
My lord, in that Platinum Jubilee celebration is by CJI as well as my lord, the lecture series by Honorable Justice, former CJI, both were my lord exempted.
If you finish your work, this will not be an appropriate forum. I'll invite you in my chamber for 2 minutes.
Okay.
Manoj, I believe, Manoj, there's this Hiramba Kumar judgment by my lords, where my lords has doubted the correctness of Kunai Ahmed. I mean, just on a point of law.
No, that is only for a different reason. You
I-
see, what had happened was, in a matter of, especially this Kunai Ahmed was referred to, you see, what has happened is, Supreme Court took a view in one of the matters that despite the SLP being dismissed, review petition was maintainable. But another coordinate bench, 3-judge bench of the Supreme Court took a very adverse view and held that the High Court could not have entertained. The language was very harsh. So therefore, we are faced with two predicaments. Number one, you see, before that, the first point is that making any comment on the order of the Superior Court that may entail a wrath which is too hurting. Mr. Dr. Ashwin Saraf has presented on the
Yes,
last date
yes.
the order. You see that view. That is one of the reasons why we may not be able to make a comment. Now, that is number one. Number two is that if I faced with a situation where I have to deal with judgment which is of a higher strength than the 3-judge bench or a 2-judge bench, then in this particular case, what had happened, that the judgment you are referring to
Yes, sir.
was a fact where a review was filed after the appellate order was there, it went to Supreme Court and it came. So now one judgment said it can be entertained because SLP dismissal of SLP does not become a
Yes.
binding precedent, and
Binding
therefore it can be.
It's
it
an
can be
incomplete dismissal.
But there's another judgment which I have said of the Supreme Court, which said that after dismissal, the High Court should not have entertained
Enter review.
review. That is why this Konayama that did not follow, because
Yes.
of the fact that there's a previous judgment which is not placed, and therefore I said that
Absolutely.
that is the reasoning I gave.
In that
Because,
context.
two judgments of 3-judge bench. Two taking diametrical opposite stands, and therefore I had to choose
To the,
one,
The one.
which
Well, the letter which I placed, that is part of the pleading 767 page matter. That RTI reply by All India.
7.
The letter which I placed just now, my lord. Yes, that is part of the pleadings at page 767. That's our reply. Rejoinder. 767 matter. আরো একটা ভলিউম আছে নাকি?
Seven, 6, 7, you said?
Yes, my lord. It's a rejoinder by us, my lord.
Yes.
Here in this case, my lord, this is, my lord, very sad history of a school teacher who was retired in 2018, my lord, without getting provision of his service. What happened in this case, my lord? Under the 2013 Act of Provincial Acts of the Assam Franchise Institution Act, my lord, of 2013, the services of the petitioner's school were provincialized, my lord, under that act, my lord. And the course of the petition was also sanctioned, my lord. But the service was not provincialized due to, my lord, missing of documents before the state, my lord, state level committee, my lord, state level scrutiny committee. And ultimately, my lord, again, my lord, petitioner resubmitted his documents before the director, and director submitted a fresh proposal to the government to provisionalize the service of the petitioner, my lord. That, my lord, proposal was sent in 2016. But even on the fresh proposal of the director, my lord, government did not act. Government did not provisionalize the service of the petitioner, and then petitioner preferred an earlier writ petition, my lord, before this court, my lord. In the meantime, my lord, the earlier 2013 Act was repealed, my lord. It was, my lord, struck down by the Honorable Court, my lord, in a division bench judgment, my lord. Then what happened? The petitioner preferred a writ appeal before this court, my lord. Writ appellate court, my lord, directed the government, the present petitioner, my lord, to submit a representation under the new act to get his service provincialized, my lord. Then under the 2017 Act, my lord, petitioner submitted a representation to the commissioner and secretary. Till then, my lord, government have not done anything, my lord, has not done anything, my lord. In 2018, my lord, the commissioner passed a, my lord, direction to the director to send the proposal, my lord. There is a letter, my lord. It was submitted by the, my lord, the Education Council earlier. It is a letter of 2018, 31st of October, my lord. Or else it may be in the record, my lord. By this letter, my lord, the commissioner secretary, my lord, directed the director, secondary education, my lord, to submit the proposal for provincial of this petitioner services as a my lord tutor, my lord.
My lord, in this matter, I have already communicated the officials. My lord, today office is closed, my lord, due to holiday, my lord. So they inform me after some time, we will inform you that what is happened to that. And my lord, moreover, she is already retired, my lord.
No, even if he's retired, if the documents are lost at your end, you'll have to take a decision whether you are, you have formally approved his proposal or you have rejected it.
Yes, my lord, I have already communicated. So they told me that.
This is a big
we
fact, my
will,
lord.
2018 matter. So 2018 matter.
Yes, madam.
By when they'll inform you?
They told me that just now, we will inform you that what happened to the petitioner.
Okay, we'll list it on Monday. By Monday, you
Yes,
complain,
ma'am.
otherwise we'll dispose of the petition.
Yes, ma'am.
Monday.
Otherwise, my lord, there is another issue for the purpose of hearing also, my lord, I can advance my submission in another way also, because this service, my lord, of the petitioner ought to have been provincially under the 2013 Act. Because the other staff of the school who were provincially under that Act, even my post was also sanctioned under that Act.
No, that won't be a valid argument because of the division bench order of this course.
Okay, sir. That is the only reason, my lord, I cannot advance argument. Otherwise, my lord, law is very clear. Even there is a judicial decision of the Supreme Court, even this court also, that under the General Clause Act, Section 6, my lord, the substantive right of the petitioner that was created under the 2013 Act even cannot be, my lord, curtailed even by the, my lord, repealing act or the even the new Act of 2017. Because the new Act, it is a it was prospective.
That argument will not be acceptable because if you are using section 6, your substantive right would have accrued on that day, but on that day, it was only a proposal. The proposal, unless acted upon, won't create a indefeasible right.
No, my lord, not only provision, my lord. The post was sanctioned because three posts of assistant teacher were provincialized. 3 teachers. I was the 3rd teacher. So my post was my service was provincialized because of my missing, my lord. The only ground.
See, three posts were created,
My lord.
but the appointees
Yes,
must be made by a separate order. Unless that order exists,
my lord.
your substantive right is not created.
So for the, my lord, documents is concerned, my lord, if my lord, lordship may kindly come to page number 20 of my repetition.
You see, I'll ask you a question I'll reframe the question in a different way.
My lord.
You see, let us say, Director of Elementary Education,
My lord.
his order has been signed by the governor and he is to join,
My lord.
correct?
My
But today at 12 o'clock, he is to join
My lord.
service.
My lord.
And this court at 10:30
My lord.
stays the appointment. Correct. The Director of Elementary Education was to join today at 12 o'clock, and at 10:30, I stay the appointment.
Order.
Now, and in course of time, the order of appointment is rejected. It's what you call interfered with,
Right.
set aside. Now, can somebody come and make an argument that substantive right has accrued in his favor because of that? The order of the governor has already been released.
So, that he cannot claim because if that is set aside or is.
So therefore, you same thing. You see, in your case, you were a candidate for appointment as a third teacher.
My lord.
Before that appointment, 55,
My lord.
somebody else was appointed.
So, other candidate was not appointed in my place.
No, may not be. So let us say you have not been appointed,
3 posts were sanctioned.
but you were not appointed.
The first assistant teacher was post was he retired, so his post was.
No, it's
vacant.
okay. This Jagan Chandra Gogoi,
My lord.
he could not join for one reason or the other.
True,
Correct.
True, my lord.
Now that act itself goes,
My lord.
so your substantive right will not be available under the old repealing act. Although
So-
you had you were a candidate, your candidature was there, you were the.
My lord,
what
that
you
is
call-
correct, my lord. But otherwise, my lord, if the interpretation of the earlier 2013 Act is done properly, my lord, in proper way, that what the section 4 of the earlier 2013 Act says, my lord. My lord, for a moment, if that act, my lord.
No, we'll hear it on Monday. We'll hear you on Monday.
My lord, Monday is holiday, my lord.
Oh, Monday is holiday, right? Then Wednesday.
So otherwise, if the government had provisional in my salary as a teacher also, my lord, I would not have hesitated the matter because the person, my lord, he was a high school teacher, joined in 1989. In 2018, he retired, my lord, without getting any benefit. Now his condition is very bad, very sad condition, my lord. A person
That's okay, we'll take it up.
rendering this long years of service in the,
We'll take it on 26th. 26th, no adjournment.
25th, my lord.
My lord, three teachers were, my lord, graduate teacher was provincialized. My lord, out of that, one teacher retired in the meantime. So it was taken at that time, my lord.
No, whatever
No,
be,
okay,
on
ma'am.
26th, you
Yes.
get this information. 26th will not adjourn the matter.
Yes, ma'am.
All right.
Good afternoon.
Mr. M.A. Islam,
Amazed.
your counsel for the petitioner is present.
You Sharma for the
Mr. U.
secondary.
Sharma,
department.
learned studying counsel for the secondary education department. Prays for a day's time to obtain instructions. Next para. The learned counsel for the petitioner has submitted that the petitioner was otherwise eligible to be appointed as a third teacher in the school concerned. But as the documents were lost in the office of the secondary education department, the service of the petitioner was not provincialized. It is projected that once again the documents of the petitioner was forwarded to the Director of Secondary Education, Assam. So, however, in the meantime, some venture educational institution within bracket provincialization of services bracket post act 2011 was declared ultra vires and accordingly a new enactment being Assam education within bracket provincialization bracket closed of services of teachers and reorganization of educational institution Act 2017 was enacted. To stop. Although the petitioner was due to retire in the month of October 2018, as his documents were not possessed, the petitioner had approached this court.
Forest Malad, 2000 Malad, yes, ma'am.
You had approached the court earlier. You said.
Earlier, Malad, in 2016 itself, Malad, because my proposal was kept pending by the authorities.
Okay, in the year 2016.
So it was WBC number 6602 of 17, Malad.
It's okay, 2016. And thereafter you went to appellate court.
Writ appeal, Malad, the writ appeal number 61 of 18.
And against the order passed in the said petition, the petitioner preferred a writ appeal. And in the writ appeal, this court had directed the petitioner to submit a representation before the authorities for being given a consideration. As the representation was not disposed of, the petitioner has approached this court again. Next paragraph. In this in connection with this writ petition, comma, notice of motion was issued by order dated 27/8/2018. But till date, the secondary education department has not filed their affidavit in opposition or have provided due instructions to their learned standing counsel. Next, accordingly, the court is inclined to provide that in the event an affidavit in opposition is not filed on or before 25/4/2023, and of the appropriate instructions with records are not furnished to the learned standing counsel for the secondary education department. Comma, the Commissioner Secretary to the Government of Assam, Education within brackets secondary bracket close department, comma, Director of Secondary Education Assam, Inspector of Schools, comma, Golaghat, shall be personally present in court with all relevant records and be prepared to assist their learned standing counsel to respond to the court queries. Next para. The pendency of the petitioner shall not be a bar for the authorities to dispose of the representation of the petitioner. Dated
my lord. Okay. 11/7/2018, my lord.
11/7/2018. And to give. And if the petitioner is found entitled to any relief, comma, appropriate relief. To provide the appropriate relief to the petitioner. Next, list on 26/4/2023. Next,
I have to place instruction, my lord.
Either instructions or
Yes, my lord.
with records or affidavit.
Yes.
Otherwise, these three other officers will be present. As per
This
the
is
learned
actually all are
standing-
holidays.
The learned standing counsel for the secondary education department shall transmit a downloaded copy of this order to the authorities to bring the order to the notice of the said authorities.
Yes.
Take a break and come back.
Yes.
Anybody is ready for part 2 hearing?
I have item 67, madam.
Item 67. Who is for the other side?
Education Department. rules.
No, that day I also told you if you are taking up this matter, you should have asked Mr. Hardik Kakoti. You can get him.
Yes, the-
Because if I am jumping the list, the other side should be present.
I'll inform you.
Either him or his or his chambermates, I think Mr. B. Purkash. So
If you persist, dear.
just get them, anybody for the private respondents. If all sides are present, I'll take up any part 2 matter. It's ready. Yes, Mr. Purkash, so you're ready with the matter. Oh,
Item number 63, higher education is the other side.
63. Okay. You ready with the matter? Higher education. Mr. A. Samuha. A. Samuha.
UGC also there. That's a modest for UGC.
SCUGC. Just wait for the other side to come. Are you ready with the file 63?
Can it be on any other day, my lord? Actually, file